if this is going to make it better. Let's see. Nah, we're not going to futz with that right now. Alright. Should be good enough. Let's see. Alright. Awesome. So, we'll begin. The Malleus Maleficarum, the Witch Hammer, Part 3. General and Introductory. Who are the fit and proper judges in the trial of witches? The question is whether witches, together with their patrons and protectors and defenders, are so entirely subject to the jurisdiction of the diocesan ecclesiastical court and the civil court, so that the inquisitors of the crime of heresy can be altogether relieved from the duty of sitting in judgment upon them. And it is argued that this is so, for the canon says, certainly, those whose high privilege it is to judge concerning matters of the faith ought not to be distracted by other business, and inquisitors deputed by the apostolic see to inquire into the pest of heresy should manifestly not have to concern themselves with diviners and soothsayers, unless these are also heretics, nor should it be their business to punish such, but they may leave them to be punished by their own judges. Nor does there seem any difficulty in the fact that the heresy of witches is not mentioned in that canon, for those are subject to the same punishment as the others in the court of conscience, as the canon goes on to say, distinction 1, prodilection, if the sin of the diviners and witches is secret, a penance of 40 days shall be imposed upon them. If it is notorious, they shall be refused the Eucharist, and those whose punishment is identical should receive it from the same court. Then again, the guilt of both being the same, since just as soothsayers obtain their results by curious means, so do witches look for and obtain from the devil the injuries which they do to creatures, unlawfully seeking from his creatures that which should be sought from God alone. Therefore both are guilty of the sin of idolatry. This is the sense of Ezekiel 21:23, that the king of Babylon stood at the crossroads, shuffling his arrows and interrogating idols. Again, it may be said that when the canon says, unless these are also heretics, it allows that some diviners and soothsayers are heretics, and should therefore be subject to trial by the inquisitors. But in that case, artificial diviners would also be so subject, and no written authority for that can be found. Again, if witches are to be tried by the inquisitors, it must be for the crime of heresy, but it is clear that the deeds of witches can be committed without any heresy. For when they stamp into the mud the body of Christ, although this is a most horrible crime, yet it may be done without any error in the understanding, and therefore without heresy. For it is entirely possible for a person to believe that it is the Lord's body, and yet throw it into the mud to satisfy the devil, and this by reason of some pact with him, that he may obtain some desired end, such as the finding of a treasure or anything of that sort. Therefore the deeds of witches need involve no error in faith, however great the sin may be, in which case they are not liable to the court of the Inquisition, but are left to their own judges. Again, Solomon showed reverence to the gods of his wives out of complacence, and was not on that account guilty of apostasy from the faith. For in his heart he was faithful, and kept the true faith. So also when witches give homage to devils by reason of the pact they have entered into, but keep the faith in their hearts, they are not on that account to be reckoned as heretics. But it may be said that all witches have to deny the faith, and therefore must be judged heretics. On the contrary, even if they were to deny the faith in their hearts and minds, still they could not be reckoned as heretics, but as apostates. But a heretic is different from an apostate, and it is heretics who are subject to the court of the Inquisition. Therefore, witches are not so subject. Again it is said, let the bishops and their representatives strive by every means to rid their parishes entirely of the pernicious art of soothsaying and magic derived from Zoroaster. And if they find any man or woman addicted to this crime, let him be shamefully cast out of their parishes in disgrace. So when it says at the end of circa 348, let them leave them to their own judges, and since it speaks in the plural, both of the ecclesiastic and the civil court, therefore, according to this canon, they are subject to no more than the diocesan court. But if, just as these arguments seem to show it to be reasonable in the case of inquisitors, the diocesans also wish to be relieved of their responsibility, and to leave the punishment of witches to the secular court, such a claim could be made good by the following arguments. For the canon says, chapter Ut Inquisitionis, we strictly forbid the temporal lords and rulers and their officers in any way to try to judge this crime, since it is purely an ecclesiastical matter, and it speaks of the crime of heresy. It follows, therefore, that when the crime is not purely ecclesiastical, as it is the case with witches, because of the temporal injuries which they commit, it must be punished by the civil and not by the ecclesiastical court. Besides, in the last canon law concerning Jews it says, his goods are to be confiscated, and he is to be condemned to death, because with perverse doctrine he opposed the faith of Christ. But if it is said that this law refers to Jews who have been converted and have afterwards returned to the worship of the Jews, this is not a valid objection. Rather is the argument strengthened by it, because the civil judge has to punish such Jews as apostates from the faith, and therefore witches who abjure the faith ought to be treated in the same way, for abjuration of the faith, either wholly or in part, is the essential principle of witches. And although it says that apostasy and heresy are to be judged in the same way, yet it is not part of the ecclesiastical but of the civil judge to concern himself with witches. For no one must cause a commotion among the people by reason of a trial for heresy, but the governor himself must make provision for such cases. The Authentics of Justinian, speaking of ruling princes, says, you shall not permit anyone to stir up your province by reason of a judicial inquiry into matters concerning religions or heresies, or in any way allow an injunction to be put upon the province over which you govern. But you shall yourself provide, making use of such moneys and other means of investigation as are competent, and not allow anything to be done in matters of religion except in accordance with our precepts. It is clear from this that no one must meddle with a rebellion against the faith, except the governor himself. Besides, if the trial and punishment of such witches were not entirely a matter for civil judge, that would be the purpose of the laws, which provides as follows. All those who are commonly called witches are to be condemned to death, and again, those who harm innocent lives by magic arts are to be thrown to the beasts. Again, it is laid down that they are to be subjected to questions and tortures, and that none of the faithful are to associate with them, under pain of exile and the confiscation of all their goods. And many other penalties are added, which anyone may read in those laws. But in contradiction of all these arguments, the truth of the matter is that such witches may be tried and punished conjointly by the civil and ecclesiastical courts. For a canonical crime must be tried by the governor and the metropolitan of the province, not by the metropolitan alone, but together with the governor. This is clear in the Authentics, where ruling princes are enjoined as follows. If it is canonical matter which is to be tried, you shall inquire into it together with the metropolitan of the province. And to remove all doubt on this subject, the gloss says, if it is a simple matter of the observance of the faith, the governor alone may try it. But if the matter is more complicated, then it must be tried by a bishop and the governor, and the matter must be kept within decent limits by someone who has found favor with God, who shall protect the orthodox faith and impose suitable indemnities of money, and keep our subjects inviolate, that is, shall not corrupt the faith in them. And again, although a secular prince may impose the capital sentence, yet this does not exclude the judgment of the Church, whose part it is to try and judge the case. Indeed, this is perfectly clear from the canon law in the chapters De Summa Trin and Fid Cath, and again in the law concerning heresy, chapter Ad Obdolendum and chapter Urgentis and chapter Excommunicamus, Communicamus 1 and 2, for the same penalties are provided by both the civil and the canon laws, as is shown by the canon laws concerning the Manichaean and Arian heresies. Therefore, the punishment of witches belongs to both courts together, and not to one separately. Again, the laws decree that clerics shall be corrected by their own judges, and not by the temporal or secular courts, because their crimes are considered to be purely ecclesiastical. But the crime of witches is partly civil and partly ecclesiastical, because they commit temporal harm and violate the faith. Therefore, it belongs to the judges of both courts to try, sentence, and punish them. This opinion is substantiated by the Authentics, where it is said, if it is an ecclesiastical crime needing ecclesiastical punishment and fine, it shall be tried by a bishop who stands in favor with God, and not even the most illustrious judges of the province shall have a hand in it. And we do not wish the civil judges to have any knowledge of such proceedings, for such matters must be examined ecclesiastically, and the souls of the offenders must be corrected by ecclesiastical penalties, according to the sacred and divine rules which our laws worthily follow, so it is said. Therefore it follows that on the other hand a crime which is of a mixed nature must be tried and punished by both courts. We make our answer to all the above as follows. Our main object here is to show how, with God's pleasure, we inquisitors of Upper Germany may be relieved of the duty of trying witches, and leave them to be punished by their own provincial judges. And this because of the arduousness of the work, provided always that such a course shall in no way endanger the preservation of the faith and the salvation of souls. And therefore we engaged upon this work that we might leave to the judges themselves the methods of trying, judging, and sentencing in such cases. Therefore, in order to show that the bishops can in many cases proceed against the witches without the inquisitors, although they cannot so proceed without the temporal and civil judges in cases involving capital punishment, it is expedient that we set down the opinions of certain other inquisitors in parts of Spain, and, saving always the reverence due to them, since we all do belong to one and the same order of preachers, to refute them, so that each detail may be more clearly understood. Their opinion is, then, that all witches, diviners, necromancers, and in short, all who practice any kind of divination, if they have once embraced and professed the holy faith, are liable to the inquisitorial court. As in the 3 cases noted in the beginning of the chapter, multorum querela in the Decretals of Pope Clement concerning heresy, in which it says that neither must the inquisitor proceed without the bishop, nor the bishop without the inquisitor, although there are 5 other cases in which one may proceed without the other, as anyone who reads the chapter may see. But in one case it is definitively stated that one must not proceed without the other, and that is when the above diviners are to be considered as heretics. In the same category they place blasphemers, and those who in any way invoke devils, and those who are excommunicated and have contumaciously remained under the ban of excommunication for a whole year, either because of some matter concerning faith, or in certain circumstances not on account of the faith, and they further include several other such offenses. And by reason of this, the authority of the ordinary is weakened, since so many more burdens are placed upon us inquisitors, which we cannot safely bear in the sight of the terrible judges, who will demand from us a strict account of the duties imposed upon us. and because their opinion cannot be refuted unless the fundamental thesis upon which it is founded is proved unsound. It is to be noted that it is based upon the commentators on the canon, especially on the chapter Accusatus and Sane, and on the word Savior of heresy. Also, they rely upon the sayings of the theologians St. Thomas, Blessed Albert, and St. Bonaventura in the second book of Sentences, distinction 7. It is best to consider some of these in detail, for when the canon says, as was shown in the first argument, that the inquisitors or heresy should not concern themselves with soothsayers and diviners unless they manifestly savor of heresy, they say that soothsayers and diviners are of two sorts, either artificial or heretical. And the first sort are called diviners pure and simple, since they work merely by art, and such are referred to in the chapter De Sortilegiis, where it says the presbyter Udalricus went to a secret place with a certain infamous person, that is a diviner, says the gloss, not with the intention of invoking the devil, which would have been heresy, but that by inspecting the astrolabe he might find out some hidden thing, and this, they say, is pure divination or sortilege. Question 1. The method of initiating process. The first question, then, is what is the suitable method of instituting a process on behalf of the faith against witches? In answer to this, it must be said that there are three methods allowed by canon law. The first is when someone accuses a person before a judge of the crime of heresy, or of protecting heretics, offering to prove it, and to submit himself to the penalty of talion if he fails to prove it. The second method is when someone denounces a person, but does not offer to prove it, and is not willing to embroil himself in the matter, but says that he lays information out of zeal for the faith, or because of a sentence of excommunication inflicted by the ordinary or his vicar, or because of the temporal punishment exacted by the secular judge upon those who fail to lay information. The third method involves an inquisition, that is, when there is no accuser or informer, but a general report that there are witches in some town or place, and then the judge must proceed not at the instance of any party, but simply by the virtue of his office. Here is to be noted that a judge should not readily admit the first method of procedure. For one thing, it is not actuated by motives of faith, nor is it very applicable to the case of witches, since they commit their deeds in secret. Then, again, it is full of danger to the accuser, because of the penalty of talion, which he will incur if he fails to prove his case. Then again, it is very litigious. Let the process begin with a general citation affixed to the walls of the parish church or the town hall in the following manner: whereas we, the vicar of such and such ordinary, or the judge of such and such county, do endeavor with all our might and strive with all our whole heart to preserve the Christian people entrusted to us in unity and the happiness of the Catholic faith, and to keep them far removed from every plague of abominable heresy. Therefore we, the aforesaid judge, to whose office it belongs, to the glory and honor of the worshipful name of Jesus Christ, and for the exaltation of the holy Orthodox faith, and for the putting down of the abomination of heresy, especially in all witches in general, and in each one severally of whatever condition or estate. Here, if he is an ecclesiastical judge, let him add a summons to all priests and dignitaries of the church in the town, for a distance of 2 miles about it, who have knowledge of this notice, and he shall add, by the authority which we exercise in this district, and in virtue of holy obedience and under pain of excommunication, we direct, command, require, and admonish that within the space of 12 days, here the secular judge shall command in his own manner, under pain of penalties suitable to his office, the first 4 of which shall stand for the first warning, the second for the second, and the third for the third warning. And we give this treble canonical warning, that if anyone know, see, or have heard that any person is reported to be a heretic or a witch, or if any is suspected, especially of such practices as cause injury to men, cattle, or the fruits of the earth, to the loss of the state. But if any do not obey these aforesaid commands and admonitions by revealing such matters within the term fixed, let him know, here the ecclesiastical judge shall add, that he is cut off by the sword of excommunication. The secular judge shall add the temporal punishments, which sentence of excommunication we impose as from this time by this writing upon all and several who thus stubbornly set at naught these our canonical warnings aforesaid, and our requirement of their obedience, reserving ourselves alone the absolution of such sentence. The secular judge shall conclude in this manner, given, etc. Note also that in the case of the second method, the following caution should be observed. For it has been said that the second method of procedure and of instituting a process on behalf of the faith is by means of an information where the informer does not offer to prove his statement, and is not ready to be embroiled in the case, but only speaks because of a sentence of excommunication, or out of zeal for the faith and for the good of the state. Therefore, the secular judge must specify in his general citation or warning aforesaid that none should think that he will become liable to a penalty even if he fails to prove his words, since he comes forward not as an accuser but as an informer. And then, since several will appear to lay information before the judge, he ought to take care to proceed in the following manner. First, let him have a notary and 2 honest persons, either clerics or laymen, or if a notary is not to be procured, then let there be 2 suitable men in the place of the notary. For this is dealt with in the chapter Ut Officium es Urum, where it is said, but because it is expedient to proceed with great caution in the trial of a grave crime, that no error may be committed in imposing upon the guilty a deservedly severe punishment, we desire and command that, in the examination of the witnesses necessary in such a charge, you shall have 2 religious and discreet persons, either clerics or laymen. It goes on to say, in the presence of these persons, the depositions of the witnesses shall be faithfully written down by a public official, if one is obtainable, or, if not, by 2 suitable men. Not therefore that, having these persons, the judge shall order the informer to lay his information in writing, or at least give it clearly by word of mouth, and then the notary or the judge shall begin to process in the following manner. In the year of our Lord, on the day of the month, in the presence of me, the notary and the witnesses subscribed, north of the town of, in the diocese, as above appeared in the person at, before the honorable judge, and offered him a schedule to the following effect. Here shall follow the schedule in its entirety, but if he has not deposed in writing by word of mouth, it shall continue thus. He appeared, etc., and laid information to the judge that north of the town or parish of the diocese had said and asserted that he knew how to perform or had actually done certain injuries to the deponent or to other persons. After this, he shall immediately make the deponent take the oath in the usual manner, either on the 4 Gospels of God or on the cross, raising 3 fingers and depressing 2 in witness of the Holy Trinity, and of the damnation of his soul and body, that he will speak the truth in his depositions. And when the oath has been sworn, he shall question him as to how he knows that his depositions are true, and whether he saw or heard that to which he swears. If he says that he has seen anything, as, for example, that the accused was present at such a time of tempest, or that he had touched an animal, or had entered a stable, the judge shall ask him when he saw him, and where, and how often, and in what manner, and who were present. If he says that he did not see it, but heard of it, he shall ask him from whom he heard it, where, when, and how often, and in whose presence, making separate articles of each of the several points above mentioned. And the notary or scribe shall set down a record of them immediately after the aforesaid denunciation, and it shall continue thus. This denunciation, as we have said, having been made, the inquisitor himself did at once cause him to swear as above on the 4 Gospels, etc., that he was speaking the truth in his depositions, and did ask him how and why he knew or suspected that what he said was true. He did make answer, either that he saw or that he heard. The inquisitor did then ask him where he saw or heard this, and he answered, on the day of, the month, in the year, in the town, or the parish. He asked him how often he saw or heard it, etc., and separate articles shall be made, and the whole set down in process, as has been said, and particularly he shall be asked who shared or could share in his knowledge of the case. When all of this has been done, he shall finally be asked whether he lays his information out of ill will, hatred, or rancor, or if he has omitted anything through favor or love, or if he has been requested or suborned to lay information. Finally, he shall be enjoined by virtue of his oath to keep secret whatever he has said there, or whatever the judge has said to him, and the whole process shall be set down in writing. And when all this is completed, it shall be set down a little lower as follows. This was done at such a place on the day of the month in the year, in the presence of me, the notary or scribe, together with those associated with me in the duty of writing, and of such and such witnesses summoned and interrogated. The third method of beginning a process is the commonest and most usual one, because it is secret and no accuser or informer has to appear. But when there is a general report of witchcraft in some town or parish, because of this report the judge may proceed without a general citation or admonition as above, since the noise of that report comes often to his ears, and then again he can begin a process in the presence of the persons, as we have said before. In the year of our Lord, on the day of the month, to the ears of such and such official or judge, there came a persistent public report and rumor that north of the town or parish did or said, and such a thing savoring of witchcraft, against the faith and the common good of the state. And the whole shall be set down according to the common report, and a little lower. The case was heard on the day of the month in the year, in the presence of me, the notary of such and such authority, or of such and such a scribe, and of such and such a witnesses, who were called and interrogated. But before we proceed on to the second head, which deals with the method of conducting this sort of process, we must first say something of the witnesses who are to be examined, as to how many they should be, and what should be their condition. Since we have said that in the second method of the evidence of the witnesses is to be written down, it is necessary to know how many witnesses there should be and of what condition. The question is whether a judge may lawfully convict any person of heresy of witchcraft on the evidence of 2 legitimate witnesses, whose evidence is entirely concordant, or whether more than 2 are necessary, and we say that the evidence of witnesses is not entirely concordant when it is only partially so. That is, when 2 witnesses differ in their accounts, but agree in the substance or effect, as when one says, "She bewitched my cow," and the other says, "She bewitched my child," but they agree as to the fact of witchcraft. But here we are concerned with the case of 2 witnesses being an entire, not partial agreement, and the answer is that, although 2 witnesses seem to be enough to satisfy the rigor of law, for the rule is that which is sworn by 2 or 3 is taken for the truth, yet in a charge of this kind 2 witnesses do not seem sufficient to ensure an equitable judgment, on account of the heinousness of the crime in question, for the proof of an accusation ought to be clearer than daylight, and especially ought this to be so in the case of the grave charge of heresy. But it may be said that very little proof is required in a charge of this nature, since it takes very little argument to expose a person's guilt. For it is said in the Canon de Hereticis, excuse me, that a man makes himself a heretic if in the least of his opinions he wanders from the teachings of the path of the Catholic religion. We answer that this is true enough with the reference to the presumption that a person is a heretic, but not as regards a condemnation. For in a charge of this sort, the usual order of judicial procedure is cut short, since the defendant does not see the witnesses take the oath, nor are they made known to him, because this might expose them to grave danger. Therefore, according to the statute, the prisoner is not permitted to know who are his accusers, but the judge himself must, by virtue of his office, inquire into any personal enmity felt by the witnesses towards the prisoner. And such witnesses cannot be allowed, as will be shown later. And when the witnesses give confused evidence on account of something lying on their conscience, the judge is empowered to put them through a second interrogatory. For the less opportunity the prisoner has to defend himself, the more carefully and diligently should the judge conduct his inquiry. Therefore, although there are two legitimate and concordant witnesses against a person, even so I do not allow that this would be sufficient warrant for a judge to condemn a person on so great a charge. But if the prisoner is the subject of an evil report, a period should be set for his purgation, and if he is under strong suspicion on account of the evidence of two witnesses, the judge should make him abjure the heresy, or question him, or defer his sentence. For it does not seem just to condemn a man of good name on so great a charge on the evidence of only two witnesses, though the case is otherwise with a person of bad reputation. This matter is fully dealt with in the canon laws of heretics, where it is set down down that the bishop shall cause 3 or more men of good standing to give evidence on oath to speak the truth as to whether they have any knowledge of the existence of heretics in such a parish. Again, it may be asked whether the judge can justly condemn a person of such heresy only on the evidence of witnesses who in some respects differ in their evidence, or merely on the strength of a general accusation. We answer that he cannot do so on either of the above grounds, especially since the proofs of a charge ought, as we have said, to be clearer than daylight. And in this particular charge, no one is to be condemned on merely presumptive evidence. Therefore, in the case of a prisoner who is the subject of a general accusation, a period of purgation shall be set for him. And in the case of one who is under strong suspicion arising from the evidence of witnesses, he shall be made to abjure his heresy. But when, in spite of certain discrepancies, the witnesses agree in the main facts, then the matter shall rest with the judge's discretion. And indirectly, the question arises how often the witnesses can be examined. Question 3. Of the solemn adjuration and re-examination of witnesses. But it may be asked whether the judge can compel witnesses to swear an oath to tell the truth in a case concerning the faith or witches, or if he can examine them many times. We answer that he can do so, especially an ecclesiastical judge, and that in ecclesiastical cases, witnesses can be compelled to speak the truth, and this on oath, since otherwise their evidence would not be valid. For the canon law says, the archbishop or bishop may make a circuit of the parish in which it is rumored that there are heretics, and compel 3 or more men of good repute, or even, if it seems good to him, the whole neighborhood to give evidence. And if any through damnable obstinacy stubbornly refuse to take the oath, they shall on that account be considered as heretics. And that the witnesses can be examined several times is shown by the canon, where it says that when the witnesses have given their evidence in a confused manner, or appear to have withheld part of their knowledge for some reason, the judge must take care to examine them afresh, for he may legally do so. Question 4. Of the quality and condition of witnesses. Note that the persons under a sentence of excommunication, associates and accomplices in the crime, notorious evildoers and criminals, or servants giving evidence against their masters, are admitted as witnesses in a case concerning the faith. And just as a heretic may give evidence against a heretic, so may a witch give against a witch. But this only in default of other proofs. And such evidence can only be admitted for the prosecution and not for the defense. This is true also of the evidence of the prisoner's wife, sons, and kindred, for the evidence of such has more weight in proving charge than in disproving it. This is made clear in the chapter Infidei de Hair, where it says, as a protection of the faith, we allow that in a case of inquiry into the sin of heresy, persons under excommunication and partners and accomplices in the crime shall be admitted as witnesses in default of other proofs against heretics and their patrons, protectors and defenders, provided that it appears probably both from the number of the witnesses and of those against whom they give evidence, and from other circumstances, that they are not giving false testimony. The case of evidence given by perjurers, when it is presumed that they are speaking out of zeal for the faith, is dealt with in Canon Chapter Accusatus, where it says that the evidence of perjurers, after they have repented, is admissible, and it goes on to say, if it manifestly appears that they do not speak in a spirit of levity, or from motives of enmity, or by reason of a bribe, but purely out of zeal for the orthodox faith, wishing to correct what they have said, or to reveal something about which they had kept silent, in defense of the faith, their testimony shall be as valid as that of anyone else, provided that there is no other objection to it. And it is clear, from the same chapter of the canon, that the testimony of men or of low repute, and criminals, and of servants against their masters, is admitted, for it says, so great is the plague of heresy that, in an action involving this crime, even servants are admitted as witnesses against their masters, and any criminal evildoer may give evidence against any person soever. Question 5. Whether mortal enemies may be admitted as witnesses. But if it is asked whether the judge can admit the mortal enemies of the prisoner to give evidence against him, in such a case we answer that he cannot, for the same chapter of the canon says, you must not understand that in this kind of charge a mortal personal enemy may be admitted to give evidence. Henry of Segusio also makes this quite clear, but it is mortal enemies that are spoken of, and it is to be noted that a witness is not necessarily to be disqualified because of every sort of enmity. And a mortal enmity is constituted by the following circumstances: when there is a death feud or vendetta between the parties, or when there has been an attempted homicide or some serious wound or injury, which manifestly shows that there is mortal hatred on the part of the witness against the prisoner, and in such case it is presumed that, just as the witness has tried to inflict temporal death on the prisoner by wounding him, so he will also be willing to effect his object by accusing him of heresy, and just as he wished to take away his life, so he would be willing to take away his good name. Therefore the evidence of such mortal enemies is justly disqualified. But there are other serious degrees of enmity, for women are easily provoked to hatred, which need not totally disqualify a witness, although they render his evidence very doubtful, so that full credence cannot be placed in his words unless they are substantiated by independent proofs, and other witnesses supply an indubitable proof of them. For the judge must ask the prisoner whether he thinks that he has any enemy who would dare to accuse him of that crime out of hatred, so that he might compass his death. And if he says that he has, he shall ask who that person is, and then the judge shall take note whether the person named as being likely to give evidence from motives of malice has actually done so. And if it is found that this is the case, and the judge has learned from trustworthy men the cause of that enmity, and if the evidence in question is not substantiated by other proofs and the words of other witnesses, then he may safely reject such evidence. But if the prisoner says that he hopes he has no such enemy, but admits that he has had quarrels with women, or if he says that he has an enemy, but names someone who, perhaps, has not given evidence, in that case, even if other witnesses say that such a person has given evidence from motives of enmity, the judge must not reject his evidence, but admit it together with the other proofs. There are many who are not sufficiently careful and circumspect, and consider that the depositions of such quarrelsome women should be altogether rejected, saying that no faith can be placed in them, since they are nearly always actuated by motives of hatred. Such men are ignorant of the subtlety and precautions of magistrates, and speak and judge like men who are color-blind. But these precautions are dealt with in questions 11 and 12. Question 6. How the trial is to be proceeded with and continued, and how the witnesses are to be examined in the presence of 4 other persons, and how the accused is to be questioned in 2 ways. In considering the method of proceeding with a trial of a witch in the cause of faith, it must be first noted that such cases must be conducted in the simplest and most summary manner, without the arguments and contentions of advocates. This is explained in the canon as follows. It often happens that we institute a criminal process and order it to be conducted in a simple, straightforward manner, without the legal quibbles and contentions which are introduced in other cases. Now much doubt had been experienced as to the meaning of these words, and as to exactly in what manner such cases should be conducted. But we, desiring as far as possible to remove all doubt on the matter, sanction the following procedure once and for all as valid. The judge to whom we commit such a case need not require any writ or demand that the action should be contested. He may conduct the case on holidays for the sake of convenience of the public. He should shorten the conduct of the case as much as he can by disallowing all dilatory exceptions, appeals and obstructions, the impertinent contentions of pleaders and advocates, and the quarrels of witnesses, and by restraining the superfluous number of witnesses, but not in such a way as to neglect the necessary proofs. And we do not mean by this that he should omit the citation of and swearing of witnesses, to tell and not to hide the truth. And since, as we have shown, the process is to be conducted in a simple manner, and it is initiated either at the instance of an accuser or of an informer actuated by zeal, or by reason of a general outcry and rumor, therefore the judge should try to avoid the first method of beginning the action, namely, at the instance of an accusing party. For the deeds of witches in conjunction with devils are done in secret, and the accuser cannot in this case, as in others, have definite evidence by which he can make his statements good. Therefore the judge ought to advise the accuser to set aside his formal accusation, and to speak rather as an informer, because of the grave danger that is incurred by an accuser. And so he can proceed in the second manner, which is commonly used, and likewise in the third manner, in which the process is begun not at the instance of any party. It is to be noted that we have already said that the judge ought particularly to ask the informer who shares or could share in his knowledge of the case. Accordingly, the judge should call as witnesses those whom the informer names, who seem to have most knowledge of the matter, and their names shall be entered by the scribe. After this, the judge, having regard to the fact that the aforesaid denunciation of heresy involves of its very nature such a grave charge that it cannot and must not be lightly passed over, since to do so would imply an offense to the divine majesty and an injury to the Catholic faith and to the state, shall proceed to inform himself and examine the witnesses in the following manner. The witness north of such a place was called, sworn and questioned whether he knew N, naming the accused, and answered that he did. Asked how he knew him, he answered that he had seen and spoken with him on several occasions, or that they had been comrades, so explaining his reason for knowing him. Asked for how long he had known him, he answered, for 10 or for so many years, asking concerning his reputation, especially in matter concerning the faith, he answered that in his morals he was good or bad man. But with regard to his faith, there was a report in such a place that he used certain practices contrary to the faith, as a witch. Asked what was the report, he made answer. Asked whether he had seen or heard him doing such things, he again answered accordingly. Asked where he had heard him use such words, he answered, in such a place. Asked in whose presence, he answered, in the presence of such and such. Further, he was asked whether any of the accused kindred had formerly been burned as witches, or had been suspected, and he answered. Asked whether he associated with suspected witches, he answered. Asked concerning the manner and reason of the accused's alleged words, he answered, for such a reason and in such a manner. Asked whether he thought that the prisoner had used those words carelessly, unmeaningly, and thoughtlessly, or rather with deliberate intention, he answered that he had used them jokingly, or in temper, or without meaning or believing what he said, or else with deliberate intention. Asked further how he could distinguish the accused's motives, he answered that he knew it because he had spoken with a laugh. This is a matter which must be inquired into very diligently, for very often people use words quoting someone else, or merely in temper, or as a test of the opinions of other people, although sometimes they are used assertively with definite intention. He was further asked whether he made this deposition out of hatred or rancor, or whether he had suppressed anything out of favor or love, and he answered, etc. Following this, he was enjoined to preserve secrecy. This was done at such a place on such a day in the presence of such witnesses called and questioned, and of me the notary or scribe. Here it must always be noted that in such an examination at least 5 persons must be present, namely the presiding judge, the witness or informer, the respondent or accused, who appears afterwards, and the third is the notary or scribe. Where there is no notary, the scribe shall co-opt another honest man, and these two, as has been said, shall perform the duties of the notary. And this is provided by the apostolic authority, as was shown above, that in this kind of action 2 honest men should perform as it were their duty of witnesses of the depositions. Also it must be noted that when a witness is called, he must also be sworn. That is, he must take the oath in the manner we have shown, otherwise he would falsely be described as called and sworn. In the same way, the other witnesses are to be examined, and after this the judge shall decide whether the fact is fully proven, and if not fully, whether there are great indications and strong suspicions of its truth. Observe that we do not speak of a light suspicion arising from slight conjectures, but of a persistent report that the accused has worked witchcraft upon children or animals, etc. Then if the judge fears the escape of the accused, he shall cause him or her to be placed in custody. But if he does not fear his escape, he shall have him called for examination. But whether or not he places him in custody, he shall first cause his house to be searched, unexpectedly, and all chests to be opened, and all boxes in the corners, and all implements of witchcraft which are found to be taken away. And having done this, the judge shall compare together everything of which he has been convicted or suspected by the evidence of witnesses, and conduct an interrogatory on him, having with him a notary, etc., as above, and having caused the accused to swear by the 4 Gospels of God to speak the truth concerning both himself and others, and they shall all be written down in this following manner. The accused of such a place was sworn by personally touching the 4 Gospels of God to speak the truth concerning both himself and others, and was then asked whence he was and from where he originated, and he answered, from such a place in such a diocese. Asked who were his parents, and whether they were alive or dead, he answered that they were alive in such a place, or dead in such a place. Asked whether they died a natural death or were burned, he answered in such a way. Here note that this question is put because, as was shown in the second part of this work, witches generally offer or devote their own children to devils, and commonly their whole progeny is infected, and when the informer has deposed to this effect, and the witch herself has denied it, it lays her open to suspicion. Asked where he was brought up, and where he chiefly lived, he answered, in such or such a place. And if it appears that he has changed abode because, perhaps, his mother or any of his kindred was not suspected, and had lived in foreign districts, especially in such places as are most frequentedly by witches, he shall be questioned accordingly. Asked why he had moved from his birthplace and gone to live in such or such a place, he answered, for such a reason. Asked whether in those said places or elsewhere he had heard any talk of witches, as, for example, the stirring up of tempests, the bewitching of cattle, the depriving of cows of their milk, or any such matter of which he was accused. If he should answer that he had, he must be asked what he had heard, and all that he says must be written down. But if he denies it, and says that he has heard nothing, then he must be asked whether he believes that there are such things as witches, and that such things as were mentioned could be done, as that tempests could be raised, or men and animals bewitched. Not that for the most part witches deny this at first, and therefore this engenders a great suspicion than if they were to answer that they left it to a superior judgment to say whether there were such or not. So if they deny it, they must be questioned as follows. Then are they innocently condemned when they are burned? And he or she must answer. Let the judge take care not to delay the following questions, but to proceed at once with them. Let he be asked why the common people fear her, and whether she knows that she is defamed and hated, and why she had threatened such a person, saying, You shall not cross me with impunity. And let her answer be noted. Then let he be asked what harm that person had done her, that she should have used such words to threaten him with injury, and note that this question is necessary in order to arrive at the cause of their enmity. For in the end, the accused will allege that the informer has spoken out of enmity. But when this is not mortal, but only a womanish quarrel, it is no impediment. For this is a common custom of witches, to stir up enmity against themselves by some word or action, as, for example, to ask someone to lend them something, or else they will damage his garden, or something of that sort, in order to make an occasion for deeds of witchcraft. And they manifest themselves either in word or in action, since they are compelled to do so at the instance of the devils, so that in this way the sins of judges are aggravated while the witch remains unpunished. For note that they do not do such things in the presence of others, so that if the informer wishes to produce witnesses, he cannot do so. Note again that they are spurred on by the devils, as we have learned from many witches who have afterwards been burned, so that often they have to work witchcraft against their own wills. Further, she was asked how the effect would follow from those threats, as that a child or animal should so quickly be bewitched, and she asked, Why did you say that he would never know a day of health, and it was so? She answered, And if she denies everything, let her be asked concerning other bewitchments, alleged by other witnesses, upon cattle or children. Asked why she was seen in the fields or in the stable with the cattle, and touching them, as is sometimes their custom, she answered. Asked why she touched a child, and afterwards it fell sick, she answered. Also she was asked what she did in the fields at the time of a tempest, and so with many other matters. Again, why having 1 or 2 cows, she had more milk than her neighbors, who had 4 or 6. Again, let her be asked why she persists in a state of adultery or concubinage, for although this is beside the point, yet such questions engender more suspicion than would the case with a chaste and honest woman who stood accused. And not that she is to be continually questioned as to the depositions which have been laid against her, to see whether she always returns to the same answers or not, and when this examination has been completed, whether her answers have been negative or affirmative or ambiguous, let them be written down, executed in such a place, etc., as above. Let's see. Question 7. In which various doubts are set forth with regard to foregoing questions and negative answers, whether the accused is to be imprisoned and when she is to be considered manifestly taken in the foul heresy of witchcraft. This is the second action. It is asked first, what is to be done when, as often happens, the accused denies everything? We answer that the judge has 3 points to consider, namely, her bad reputation, the evidence of the fact, and the words of the witnesses, and he must see whether all these agree together. And if, as very often is the case, they do not altogether agree together, since witches are variously accused of different deeds committed in some village or town, but the evidences of the fact are visible to the eye, as that a child has been harmed by sorcery, or more often a beast has been bewitched or deprived of its milk. And if a number of witnesses have come forward whose evidence, even if it is shown certain discrepancies, as that one should say she had bewitched his child, another his beast, and a third should merely witness to her reputation, and so with the others, but nevertheless agree in the substance of the fact, that is, as to the witchcraft, and that she is suspected of being a witch, although those witnesses are not enough to warrant a conviction without the fact of the general report, or even with that fact, as was shown above at the end of question 3, yet taken in conjunction with the visible and tangible evidence of the fact, the judge may, in consideration of these 3 points together, decide that the accused is to be reputed, not as strongly or gravely under suspicion, which suspicions will be explained later, but as manifestly taken in the heresy of witchcraft, provided that the witnesses are of a suitable condition, and have not given evidence out of enmity, and that a sufficient number of them, say 6 or 8 or 10, have agreed together under oath. And then, according to the canon law, he must subject her to punishment, whether she has confessed her crime or not, and this is proved as follows. For since it is said that when all 3 of the above considerations are in agreement, then she should be thought to be manifestly taken in heresy. It must not be understood that it is necessary for all 3 to be in agreement, but only that if this is the case, the proof is all the stronger. For either one instance by itself of the following 2 circumstances, namely, the evidence of the fact and the production of legitimate witnesses, is sufficient to cause a person to be reputed as manifestly taken in heresy, and all the more when both these considerations are in agreement. For when the jurists ask in how many ways a person may be considered as manifestly taken in heresy, we answer that there are 3 ways, as St. Bernard has explained. This matter was treated of above in the first question at the beginning of this work, namely, the evidence of the fact, when a person has publicly preached heresy. But here we consider the evidence of the fact provided by the public threats uttered by the accused, as when she said, "You shall have no healthy days," or some such thing, and the threatened effect has followed. The other 2 ways are the legitimate proof of the case by witnesses, and thirdly, by her own confession. Therefore, if each of these singly is sufficient to cause a person to be manifestly suspected, how much more is this the case when the reputation of the accused, the evidence of the fact, and the depositions of witnesses altogether point to the same conclusion. It is true that St. Bernard speaks of an evident fact, and we here speak of the evidence of the fact, but this is because the devil does not work openly, but secretly. Therefore, the injuries and the instruments of witchcraft which are found constitute the evidence of the fact, and whereas in other heresies an evident fact is alone sufficient, here we join 3 proofs together. Secondly, it is thus proved that a person so taken is to be punished according to the law, and even though she denies the accusation, for a person taken on the evidence of the fact, or on the depositions of witnesses, either confesses the crime or does not. If he confesses and is impenitent, he is to be handed over to the secular courts to suffer the extreme penalty, according to the chapter ad abolidem, or he is to be imprisoned for life, according to the chapter Excommunicamus. But if he does not confess, and stoutly maintains his denial, he is to be delivered as an impenitent to the power of the civil court, to be punished in a fitting manner, as Henry of Segusio shows in his Summa, where he treats the manner of proceeding against heretics. It is therefore concluded that it is most just if the judge proceeds in that manner with his questions and the depositions of witnesses, since, as he has been said, he can, in a case concerning the faith, conduct matters quite plainly and in a short and summary manner. And it is meet that he should consign the accused to prison for a time, or for several years, in case, perhaps, being depressed after a year of the squalor of prison, she may confess her crimes. But lest it should seem that he arrives at his sentence precipitately, and to show that he proceeds with all equity, let us inquire into what should next be done. Question 8. Which follows from the preceding question, whether the witch is to be imprisoned, and of the method of taking her, this is the third action of the judge. It is asked whether after she has denied the accusation, the witch ought to be kept in custody in prison, when the three aforesaid conditions, namely, her reputation, the evidence of the fact, and the depositions of witnesses, are in agreement, or whether she should be dismissed with the security of sureties, so that she may again be called and questioned. As to this question there are three opinions. First, it is the opinion of some that she should be sent to prison, and that by no means ought she to be dismissed under bond, and they hold this opinion on the strength of the reasoning brought forward in the preceding question, namely, that she is to be considered as manifestly guilty when all those three considerations are in agreement. Others, again, think that before she is imprisoned, she may be dismissed with the safeguard of sureties, so that if she makes her escape, she can then be considered as convicted. But after she has been imprisoned because of her negative answers, she is not to be released under any safeguard or condition of bail, that is, when those three considerations noted above are in agreement, because in that case she could not subsequently be sentenced and punished by death, and this, they say, is the general custom. The third opinion is that no definite rule can be given, but that it must be left to the judge to act in accordance with the gravity of the matter as shown by the testimony of the witnesses, the reputation of the accused, and the evidence as to the fact, and the extent to which these three agree with each other, and that he should follow the custom of the country. And they who hold this opinion conclude by saying that if reputable and responsible sureties are not to be procured, and the accused is suspected of contemplating flight, she should then be cast into prison, and this third opinion seems to be the most reasonable, as long as the correct procedure is observed. And this consists in three things. First, that her house should be searched as thoroughly as possible, and all holes and corners and chests, top and bottom, and if she is a noted witch, then without doubt, unless she has previously hidden them, there will be found various instruments of witchcraft, as we have shown above. Secondly, if she has a maidservant or companions, that she or they should be shut up by themselves, for though they are not accused, yet it is presumed that none of the accused's secrets are hidden from them. Thirdly, in taking her, if she be taken in her own house, let her not be given time to go into her room, for they are wont to secure it in this way, and bring away with them some object of power of witchcraft, which procures them the faculty of keeping silent under examination. This gives rise to the question whether the method employed by some to capture a witch is lawful, namely, that she should be lifted from the ground by the officers and carried out in a basket or on a plank of wood, so that she cannot again touch the ground. This can be answered by the opinion of canonists and of certain theologians that this is lawful in three respects. First, because, as is shown in the introductory question of this third part, it is clear from the opinion of many authorities, and especially of such doctors as no one would dare to dispute, as Duns Scotus, Henry of Segusio, and Godfrey of Fontaines, that it is lawful to oppose vanity with vanity. Also, we know from experience and the confessions of witches that when they are taken in this manner, they more often lose the power of keeping silence under examination. Indeed, many who have been about to be burned have asked that they might be allowed at least to touch the ground with one foot. And when this has been asked why they made such a request, they have answered that if they had touched the ground, they would have liberated themselves, striking many other people dead with lightning. The second reason is this. It was manifestly shown in the second part of this work that a witch loses all her power when she falls into the hands of public justice, that is, with regard to the past. But with regard to the future, unless she receives from the devil fresh powers of keeping silent, she will confess all her crimes. Therefore, let us say with St. Paul, whatsoever we do in word or deed, let all be done in the name of the Lord Jesus Christ. And if the witch be innocent, this form of capture will not harm her. Thirdly, according to the doctors, it is lawful to counteract witchcraft by vain means. For they all agree as to this, though they are at variance over the question as to when those vain means may be unlawful. Therefore, when Henry of Segusio says that it is lawful to oppose vanity with vanity, this is explained as meaning that he speaks of vain means, not of unlawful means. All the more, then, is it lawful to obstruct witchcraft, and it is this obstruction which is referred to here, and not any unlawful practice. Let the judge note, also, that there are two sorts of imprisonment, one being a punishment inflicted upon criminals, but the other only a matter of custody in the house of detention, and these two sorts are noted in the chapter Multorum Querula. Therefore, she ought at least to be placed in custody, but if it is only a slight matter of which she is accused, and she is not of bad reputation, and there is no evidence of her work upon children or animals, then she may be sent back to her house. But because she has certainly associated with witches and knows their secret, she must give sureties. And if she cannot do so, she must be bound by oaths and penalties, not to go out of her house unless she is summoned. But her servants and domestics, of whom we spoke above, must be kept in custody, yet not punished. Question 9. What is to be done after the arrest, and whether the names of witnesses should be made known to the accused? This is the fourth action. There are two matters to be attended to after the arrest, but it is left to the judge which shall be taken first, namely, the question of allowing the accused to be defended, and whether she should be examined in the place of torture, though not necessarily in order that she should be tortured. The first is only allowed when a direct request is made, the second only when her servants and companions, if she has any, have first been examined in the house. But let us proceed in the order as above. If the accused says that she is innocent and falsely accused, and that she wishes to see and hear her accusers, then it is a sign that she is asking to defend herself. But it is an open question whether the judge is bound to make the deponents known to her and bring them to confront her face to face. For here let the judge take note that he is not bound either to publish the names of the deponents or to bring them before the accused, unless they themselves should freely and willingly offer to come before the accused and lay their depositions in her presence. And it is by reason of the danger incurred by the deponents that the judge is not bound to do this. For although different popes have had different opinions on this matter, none of them has ever said that in such a case the judge is bound to make known to the accused the names of the informers or accusers. But here we are not dealing with the case of an accuser. On the contrary, some have thought that in no case ought he to do so, while others have thought that he should in certain circumstances. But finally, Boniface VIII decreed as follows: if in a case of heresy it appears to the bishop or inquisitor that grave danger would be incurred by the witnesses of informers on account of the powers of the persons against whom they laid their depositions, should their names be published, he shall not publish them. But if there is no danger, their names shall be published, just as in other cases. Here it is to be noted that this refers not only to a bishop or inquisitor, but to any judge conducting a case against witches with the consent of the inquisitor or bishop. For, as was shown in the introductory question, they can depute their deputies to a judge, so that any such judge, even if he be secular, has the authority of the Pope, and not only of the Emperor. Also, a careful judge will take notice of the powers of the accused persons, for these are of three kinds, namely, the power of birth and family, the power of riches, and the power of malice. And the last of these is more to be feared than the other two, since it threatens more danger to the witnesses if their names are made known to the accused. The reason for this is that it is more dangerous to make known the names of witnesses to the accused person who is poor, because such a person has many evil accomplices, such as outlaws and homicides, associated with him, who venture nothing but their own persons, which is not the case with any one who is nobly born or rich, and abounding in temporal possessions. And the kind of danger which is to be feared is explained by Pope John the 22nd as the death of cutting off of themselves or their children or kindred, or the wasting of their substance, or some such matter. Further, let the judge take notice that, as he acts in this matter with the authority of the Supreme Pontiff and the permission of the ordinary, both he himself and all who are associated with him at the depositions, or afterwards at the pronouncing of the sentence, must keep the names of the witnesses secret, under pain of excommunication, and it is in the power of the bishop thus to punish him or them if they do otherwise. Therefore, he should very implicitly warn them not to reveal the name from the very beginning of the process. Wherefore, the above decrees of Pope Boniface VIII goes on to say, and that the danger to those accusers and witnesses may be the more effectively met, and the inquiry conducted more cautiously, we permit, by the authority of this statute, that the bishop or inquisitors, or, as we have said, the judge, shall forbid all those who are concerned in the inquiry to reveal, without their permission, any secrets which they have learned from the bishop or inquisitors, under pain of excommunication, which they may incur by violating such secrets. It is further to be noted that just as it is punishable offense to publish the names of witnesses indiscreetly, so also it is to conceal them without good reason from, for instance, such people as have a right to know them, such as the lawyers and assessors whose opinion is to be sought in the proceeding to the sentence. In the same way, the names must not be concealed when it is possible to publish them, without risk of any danger to the witnesses. On this subject, the above decree speaks as follows, towards the end. We command that in all cases the bishop or inquisitors shall take especial care not to suppress the names of the witnesses as if there were danger to them, when there is perfect security, not conversely to decide to publish them when there is some danger threatened, the decision in this matter resting with their own conscience and discretion. And it has been written in comment on these words, whoever you are who are a judge in such a case, mark those words well, for they do not refer to a slight risk, but to a grave danger. Therefore, do not deprive a prisoner of his legal rights without very good cause, for this cannot but be an offense to Almighty God. The reader must note that all the process which we have already described, and all that we have yet to describe up to the methods of passing sentence, except the death sentence, which it is in the province of the ecclesiastical judge to conduct, can also, with the consent of the diocese, be conducted by a secular judge. Therefore, the reader need find no difficulty in the fact that the above decree speaks of an ecclesiastical and not a secular judge, for the latter can take his method of inflicting the death sentence from that of the ordinary and passing sentence of penance. Question 10. What kind of defense may be allowed and of the appointment of an advocate? This is the fifth action. If, therefore, the accused asks to be defended, how can this be admitted when the names of the witnesses are kept altogether secret? It is to be said that three considerations are to be observed in admitting any defense. First, that an advocate shall be allotted to the accused. Second, that the names of the witnesses shall not be made known to the advocate, even under an oath of secrecy, but that he shall be informed of everything contained in the depositions. Third, the accused shall, as far as possible, be given the benefit of every doubt, provided that this involves no scandal to the faith, nor is in any way detrimental to justice, as will be shown. And in like manner, the prisoner's procurator shall have full access to the whole process, only the names of the witnesses and deponents being suppressed. And the advocate can act also in the name of the procurator. As to the first of these points, it should be noted that an advocate is not to be appointed at the desire of the accused, as if he may choose which advocate he will have, but the judge must take excuse me. The judge must take great care to appoint neither a litigious nor an evil-minded man, nor yet one who is easily bribed, as many are, but rather an honorable man to whom no sort of suspicion attaches. And the judge ought to note 4 points, and if the advocate be found to conform to them, he shall be allowed to plead, but not otherwise. For first of all, the advocate must examine the nature of the case, and then, if he finds it just, 1, he may undertake it, but if he finds it unjust, he must refuse it. And he must be very careful not to undertake an unjust or desperate case. But if he has unwittingly accepted the brief, together with a fee, from someone who wishes to do him an injury, but discovers during the process that the case is hopeless, then he must signify to his client, that is the accused, that he abandons the case, and must return the fee which he has received. This is the opinion of Godfrey of Fontaines, which is wholly in conformity with the canon du jude I rem nom novam. But Henry of Segusio holds an opposite view concerning the return of the fee, in a case in which the advocate has worked very hard. Consequently, if an advocate has wittingly undertaken to defend a prisoner whom he knows to be guilty, he shall be liable for the costs and expenses. De admin tut. Yeah, we're not going to try and read all that. The second point to be observed is that in his pleading, he should conduct himself properly in 3 respects. First, his behavior must be modest and free from prolixity or pretentious oratory. Secondly, he must abide by the truth, not bringing forward any fallacious arguments or reasoning, or calling false witnesses, or introducing legal quirks and quibbles if he be a skilled lawyer, or bringing counter-accusations, especially in cases of this sort, which must be conducted as simply and summarily as possible. Thirdly, his fee must be regulated by the usual practice of the district. But to return to our point, the judge must make the above conditions clear to the advocate, and finally admonish him not to incur the charge of defending heresy, which would make him liable to excommunication. And it is not a valid argument for him to say to the judge that he is not defending the error, but the person, for he must not by any means so conduct his defense as to prevent the case from being conducted in a plain and summary manner, and he would be doing so if he introduced any complications or appeals into it. All which things are disallowed together, for it is granted that he does not defend the error, for in that case he would be more damnably guilty than the witches themselves, and rather a heresiarch than a heretical wizard. Nevertheless, if he unduly defends a person already suspect of heresy, he makes himself, as it were, a patron of that heresy, and lays himself under not only a light, but a strong suspicion, in accordance with the manner of his defense, and ought publicly to abjure that heresy before the bishop. We have put this matter at some length, and it is not to be neglected by the judge, because much danger may arise from an improper conducting of the defense by an advocate or procurator. Therefore, when there is an objection to the advocate, the judge must dispense with him, and proceed in accordance with the facts and the proofs. But when the advocate for the accused is not open to any objection, but is a zealous man and lover of justice, then the judge may reveal to him the names of the witnesses under an oath of secrecy. Just see. Question 11. What course the advocate should adopt when the names of the witnesses are not revealed to him? The sixth section. But it may be asked, what then should the advocate acting as a procurator for the accused do? When the names of the witnesses are withheld from both himself and his client, the accused earnestly desires that they should be made known. We answer that he should obtain information from the judge on every point of the accusation, which must be given to him at his request, only the names of witnesses being suppressed. And with this information, he should approach the accused and, if the matter involves a very grave charge, exhort him to exercise all the patience which he can. And if the accused again and again insists that she should know the names of the witnesses against her, he can answer her as follows. You can guess from the charges which are made against you who are the witnesses. For the child or beast of so-and-so has been bewitched. Or to such a woman or man, because they refused to lend you something for which you asked. You said, you shall know that it would have been better to have agreed to my request. And they bear witness that in consequence of your words, the person was suddenly taken ill. And facts are stronger evidence than words. And you know that you have a bad reputation, and have for a long time been suspected of casting spells upon and injuring many men. And talking in this manner, he may finally induce her to enter a plea that they had borne witness against her from motives of hatred, or to say, I confess that I did say so, but not with any intent to do harm. Therefore, the advocate must first lay before the judge and his assessors this plea of personal enmity, and the judge must inquire into it. And if it should be found to be a case of mortal enmity, as that there has been some attempted or accomplished murder committed by the husbands or kindred of the parties, or that someone of one party has been charged with a crime by someone of the other party, so that he fell into the hands of public justice, or that serious wounds have resulted from quarrels and brawls between them, then the upright and careful judge will consult with his assessors whether the accused of the deponent was the aggravating party. For if, for example, the husband or friends of the accused have unjustly oppressed the friends of the deponent, then if there is no evidence of the fact that the children or animals or men have been bewitched, and if there are no other witnesses, and the accused is not even commonly suspected of witchcraft, in that case, it is presumed that the depositions were laid against her from motives of vengeance, and she is to be discharged as innocent, and freely dismissed after having been duly cautioned against seeking to avenge herself in the manner which is usually used by judges. The following case may be put. Katharina's child, or she herself, is bewitched, or she has suffered much loss of her cattle, and she suspects the accused because her husband or brothers had previously brought on an unjust accusation against her own husband or brother. Here the cause of enmity is twofold on the part of the deponent, having its root both in her own bewitchment and in the unjust accusation brought against her husband or brother. Then ought her deposition to be rejected or not? From one point of view, it seems that it should, because she is actuated by enmity. From another point of view, it should not, because there is evidence of the fact in her bewitchment. We answer that, if in this case there are no other deponents, and the accused is not even under common suspicion, then her depositions cannot be allowed, but must be rejected. But if the accused is rendered suspect, and if the disease is not not due to natural causes, but to witchcraft, and we shall show later how this can be distinguished, she is to be subjected to a canonical purgation. If it be asked further whether the other deponents must bear witness to the evidence of the fact as experienced by themselves or others, or only to the public reputation of the accused, we answer that if they give evidence of the fact, so much the better. But if they only give evidence as to her general character, and the matter stands so, then although the judge must reject that deponent on the grounds of her personal enmity, yet he shall take the evidence of the fact and of her bad reputation given by the other witnesses as proof that the accused must be strongly suspect, and on these grounds he can sentence her to a threefold punishment, namely, to a canonical purgation because of her reputation, or to an abjuration because of the suspicion under which she rests, and there are various forms of abjuration for various degrees of suspicion, as will be shown in the fourth method of passing sentence, or because of the evidence of the fact, and if she confesses her crimes and is penitent, she shall not be handed over to the secular branch for capital punishment, but be sentenced by the ecclesiastical judge to imprisonment for life. But notwithstanding the fact that she has been sentenced to imprisonment for life, the ecclesiastical judge, the secular judge, can, on account of the temporal injuries which she has committed, deliver her to be burned. But all these matters will be made clear later when we deal with the sixth method of passing sentence. To sum up, let the judge first take care not to lend too easy belief to the advocate when he pleads mortal enmity on behalf of the accused, for in these cases it is very seldom that anyone bears witness without enmity, because witches are always hated by everybody. Secondly, let him take note that there are 4 ways by which a witch can be convicted, namely by witnesses, by direct evidence of the fact, and by her own confession. And if she is detained on account of a general report, she can be convicted by the evidence of witnesses. If on account of definite suspicion, the direct or indirect evidence of the facts can convict her. And by reason of these, the suspicion may be judged to be either light or strong or grave. All this is when she does not confess. But when she does, the case can proceed as has been said. Thirdly, let the judge make use of all the foregoing circumstances to meet the plea of the advocate, whether the accused is charged only by reason of a general report, or by whether there are certain evidences to support the charge by which she incurs slight or strong suspicion, and then he will be able to answer the advocate's allegation of personal enmity, which is the first line of defense which he may assume. But when the advocate assumes the second line of defense, admitting that the accused has used such words against the deponent as, "You shall soon know what is going to happen to you," or "You will wish soon enough that you had lent or sold me what I asked for," or some such words, and submits that although the deponent afterwards experienced some injury either to this person or his property, yet it does not follow from this that the accused was the cause of it as a witch. For illnesses may be due to various different causes. Also he submits that it is a common habit of women to quarrel together with such words, etc. The judge ought to answer such allegations in the following manner. If the illness is due to natural causes, then the excuse is good, but the evidence indicates the contrary, for it cannot be cured by any natural remedy, or in the opinion of the physicians, the illness is due to witchcraft, or is what is a common speech called a night scathe. Again, perhaps other enchantresses are of the opinion that it is due to witchcraft, or because it came suddenly, without any previous sickening, whereas natural diseases generally develop gradually, or perhaps because the plaintiff had found certain instruments of witchcraft under his bed or in his clothes or elsewhere. When these were removed, he was suddenly restored to health, as often happens, as we showed in the second part of this work, where we treated of remedies. And by some such answer as this, the judge can easily meet this allegation, and show that the illness was due rather to witchcraft than to any natural causes, and that the accused must be suspected of causing such witchcraft, by reason of her threatening words. In the same way, if someone said, "I wish your barn would be burned down," and this should afterwards happen, it would engender a grave suspicion that the person who had used that threat had caused the barn to be set on fire, even if another person, and not he himself, had actually set light to it. Alright. So, just trying to see what's left. we're going to stop there for today. So I think I should take maybe 2 more readings. I have like 40 pages left, so forget where I started today. Yeah, maybe 2 more readings of that. And then we'll be done, and I'll have another book for Mondays. All right, I'm going to take a quick break, and then we'll come and play some games. We'll see. Don't go anywhere.